All right, so let's talk hurricane preparedness. And to that, we are very lucky. We've got three outstanding talents in their respective fields that are joining us, and we're going to talk about their firm, their involvement, and the guidance as it relates to legal, recovery, insurance, and management in this important field. So I guess I'm the first pick, so I'll start off first. Most of you know Castle Group, but for those who do not, we're one of the largest property management firms in the state. We're headquartered right here in Plantation, Florida. We've been managing condominiums and HOAs for well over 30 years now. And we do that with a highly trained team of over 2,000 employees now, focusing on implementing thought leadership and best practices to both homeowners and the physical plant assets, which we'll touch about in a little bit. So making sure that we hire the best talent, we support and train that talent, and surround them with best systems and practices for high-level execution. So that's a little bit about Castle Group. I guess, Yvonne Andrus, you're next on the pick there, so take it away.
Sure. Thanks so much. Good morning, everyone. My name is Yvonne Andrus. I'm a partner with the law firm of Siegfried Rivera. It's my pleasure and honor to be here with you this morning to discuss this important topic about hurricane preparedness. Our firm is one of the larger firms within South Florida. We represent, and throughout the state, we represent over 500 condominium and homeowners associations. We deal directly with everything that impacts an association, whether it be general related work, review of condominium documents, enforcement of those documents, and even into construction and certain types of real estate matters. So again, it's a pleasure to be here this morning with you, and we look forward to this discussion.
Thank you, Yvonne. And Daniel, you're next up on the pick.
All right. Well, good morning, and thank you, Castle and its entire team, for this opportunity to be here to discuss, obviously, a very important topic. We've already had an active storm season. I founded Global Pro in 2012. Since then, we've represented thousands of community associations and business owners in the recovery of more than $1 billion in damages, as well as in assisting on a consulting services basis, the placement of insurance throughout the country. We continue to do that and thrive because we do have a team of experts here that all focus in on insurance. And I look forward to this conversation today.
Great. Thanks, Daniel. All right. Last, but certainly not least, Mr. Jordan Knowles.
Good morning, and thank you, James, for the introduction, and thanks for your team at Castle for putting this together. Good morning to all of our participants. My name is Jordan Knowles. I work with Brown & Brown Insurance out of our Fort Lauderdale office. Brown & Brown is a publicly traded nationwide firm with about 12,000 teammates and 300 offices, each of them locally focused to adapt and be nimble to our current climates that we need to deal with. My office specifically manages and places insurance portfolios for between 750 and 800 condo and homeowners associations throughout the Tri-County area. And looking forward to hopefully adding some value to your hurricane preparedness plan today and giving some best tips and hopefully have some good questions from you folks today.
Awesome. Okay. Well, thank you all. So our next slide here, Lindsay, is it's kind of a funny one. I was thinking about the name Hunker Down, and originally being a cheesehead from Wisconsin, I do know a thing or two about hunkering down, snow blizzards, snowstorms, right? Florida, I honestly, I don't think as much as like hunker bunker down. I think like, let's just get out of Dodge. So that's just that. But the main point here is, as was mentioned by Jordan, we do have 16 named storms. And how many of those will be large, catastrophic, dangerous, we don't know, but we do know it only takes one. And it is great to have these experts here talking to us as board members, as property managers, as other, to really touch upon some of the framework of how insurance and legal and recovery and management strategies really intertwine with this and where we're at. So without further ado, I'm going to start off with the question. And really one of the questions is probably for all three of you to kind of chime in at your own point in time. But what it's like for board members, for homeowners and vendors that need to be prepared. And residential HOA preparedness is different from condominium preparedness, right? There's physical buildings, there's systems, there's access points, there's egress, et cetera. And I think, on the vendor side, we see the importance here on the preparation with your partner vendors, and all of you are respectable ones in that domain. So what I'd like to ask the three of you, and maybe I'll start out with you, Jordan, is, we all know in the property management industry that we meet and coordinate with landscaping, with security guards, our site, our staff, equipment rental firms, things of that nature. And it's critical to ensure that, the property management firm and the board members and the vendors do the same to meet with insurance carriers, association attorneys, mitigation recovery firms. So to start off with that, I guess I'd like to just start with you, Jordan, which is, what do you want to address, and what are the things that you want to bring up to the community before the storm, right? Not during or after the storm. So what are those talking points that they should take note of that you approach?
Absolutely. So thank you for the question, James. It's really a bit of a two-pronged approach. From a building maintenance and safety standpoint, you want to make sure that you have reputable roofing contractors and reputable window and door contractors that you work with on a regular basis, because those are the items that are typically the first things to go in an actual storm themselves. So as your normal maintenance is ongoing throughout the course of your building, those are the two items that, from a hurricane perspective, are likely the most needed to have the most attention. So from a building safety standpoint, making sure that your maintenance is up to date on those. And again, we know that these items are becoming increasingly more expensive. So there is some pain when we get an invoice to take care of these items. But the reality of the situation is, not taking care of it in a timely manner only exasperates the end all result, which is just going to be magnified if we don't get it taken care of in a quick manner.
Okay.
From the perspective of the storm itself coming in and the standard procedure that the association and the property manager would take, make sure that there are more than just your normal lines of communication, because typically when we see a storm, people lose power, people are displaced. And what does that mean? If the board is trying to call a business that's not open, they're not going to receive the proper attention that they need. So make sure you have the cell phone number of your insurance agent. Make sure you know what their plan is in times of a storm. Brown & Brown specifically, we have 300 offices in the country. We have about 25 in the state of Florida. So what that means is if there's a storm that's barreling down the East Coast, we will send resources over to our West Coast offices, whether that be Naples, Sarasota, or St. Pete's. That way our clients can continue to call us and they don't even know the difference. That's very important for a couple of different reasons. Obviously, a swift line of communication is always of necessity, but a lot of times when you're filing claims, those are handled in a first come, first served basis. So if you're not able to get the right folks out to, if you're not able to call Dan O'Dess and get him out there the day it happens, or if you can't call your insurance company and say, hey, what are my availabilities here? Who can I contact? Who can come out here to help me? In a time of a storm, every minute counts. And not only that, but when you go to file a claim, you want to have as much accurate info as possible in the quickest possible time frame. Because what you don't want is to be in a line of 500 other claims that got filed quicker than you did because you couldn't reach your insurance agent.
That's a great point. Thank you, Jordan, for that. And then, as it relates to you, Yvonne, and Siegfried, there's actually some probably pertinent things that we'll discuss later on specific to like evacuation orders and things of that nature. But, then again, like general communication, what do you advise with both management firm and board in terms of all right, there's a named storm, it's out there, it's coming, it looks like the cone's definitely going to hit us at a certain point in time. What are the things that you want to engage quickly with management firm and the association?
So before we even get to the cone hitting us and being in South Florida being a target, or any part of the state for that matter, the 6 Ps is kind of what I usually guide my clients on, and that's the proper prior planning prevents potential problems. Those 6 Ps essentially are what an association should be doing right now in preparing for a storm and a likely threat. And we have been lucky in the sense that in the South Florida area, we haven't had a direct hit for quite some time, but we have had significant storms pass through that have caused disruption. Dorian set off our shore as almost as a Cat 5, and with a blow of the wind, literally could have been on our doorstep. So we need, one of the things that we are always suggesting to our clients is that, prepare now. Jordan had a very great comment about getting all of your documents ready, know who you need to contact, have those policies in hand and in place. But even beyond that, because that's obviously when a storm is threatening, you're going to want that. Right now, we should be starting on focusing on who's going to be taking the responsibilities for managing and clearing the property if necessary, whether it be in a homeowner association, removing the chairs from the pool, or in a condo association, making sure everything is removed from the balconies, and making sure that we have those items and those tasks or hurricane plans in place, so that way they can be quickly implemented when and needed.
Okay, great. Thank you, Yvonne. And then Daniel, it's interesting because, we're talking about before the storm, whatever that may be, days, weeks, months, and just in terms of preparedness. And, your business and your company has aspects that are very critical before, during, and after, right, in terms of mitigating and recovery. So how do you approach the associations with regards to that in advance of the storm?
Well, we have the 3 R's.
Oh, boy.
Ready, recover, rebuild. So, seriously, we do. So our process is built around that: ready, recover, rebuild. It illustrates the cyclical nature of insurance, which I have worked closely with Sigrid Rivera as well as Jordan and his entire team over at Brown & Brown on. And on the ready side, obviously, it's all about getting ready. Jordan made some really great points about getting your documents together. I would build on that and say, where are you storing them? Obviously, thumb drives, I know from my experience, if you go to any of these trade shows, which I encourage all board members to do and managers, if anything else, you'll get a free thumb drive there from someone. Use it. And store your certified copy of your insurance policy on it. That is the actual accurate copy of your policy. Make sure that you have all the forms and make sure that it's actually the current policy. We've seen associations actually get older copies of policy because they went through a renewal and just assume, oh, it's just the same insurer. We went through a renewal. It doesn't matter. Well, as Jordan will tell you, particularly right now, even if you're getting a renewal, I guarantee you there's something new or different in that policy than it was probably the year before. There's a very slim chance that there isn't. So make sure you have the most current policy and make sure that other people have access to it. Dropbox, even Facebook offer document services, which are free, electronic. And so as you evacuate or others do, we still do have snowbirds that live in their buildings down here in South Florida. So they, even if you're evacuating, don't have access, maybe they do because they're up in some cooler environments, whether it's Michigan or New York or whatever it may have been for the summer, and they can get access to it so they can report the claim promptly, timely. Promptly, timely, I want to build on again on something Jordan mentioned. Doesn't mean immediately. There's certainly a queue that forms, but the last thing you want to be doing is rushing to make a claim. Doing a proper evaluation, making sure the health and safety of your people that were left behind or stayed behind, including cats and dogs, and other pets that may have been in the building are in good condition, and that is really what's important there is a safety. And then as you start to the claims process, you're not experts. You're not experts in roofing. You're not experts in plumbing. You're not experts in these things. Again, rely on your experts, rely on the people that are actually helping you through that process. If you do work with mitigation contractors in order to repair or to mitigate your damage, which is your only obligation under your insurance policy, if they're not local, start to question their practices. Have they ever been in the area? If they haven't, probably a good idea to probably pick up the phone and call another one. You do have a lot of new faces that get down here. That's all part of that planning preparation. That's all about that ready phase, is to think about the fact that some of the contractors that you're signing those preferred vendor agreements with, or they are guaranteeing you or promising that they're going to be there,
Right.
There's no mitigation company I know right now in South Florida that has enough resources locally to be able to mitigate all of the damages from more than a Cat 1. Hurricane Irma proved that. And I don't really think anything happened. In fact, anything's changed. And in fact, I think it's actually probably worse through consolidation. You've seen actually the disbursement of resources, including adjusters. One of the things I said before is expect longer than expected delays in the claims process. There is actually less independent adjusters reportedly throughout the United States right now than there was during the 2017 storm season. We do expect a battle of the experts. So having familiarity with your systems and doing a rehearsed walkthrough. James, you and I talked about this, about what Castle does. Rehearse the walkthrough, get ready. I participate in these things all the time, the community associations, to critique and criticize what they're doing or not doing. And we get very much involved in why things should change. And just because you did it last year doesn't mean it's relevant to this year, because again, we continue to have more and more people in the local market that are not familiar with these tropical events or haven't experienced it. So do the rehearsed walkthrough. I can't explain. And one of the things you'll probably notice during the walkthrough is that you don't have access to every part of the building as you actually think you do. And which is an incredibly important part of the ready phase, is ensuring that you have access to the entirety of the building, including the units.
No, that's a very good point. It brings up a lot more ideas in my head, even myself, just kind of thinking through some of the aspects that you mentioned. One of the things I just wanted to say, Lindsay, I didn't want to forget, with regards to the questions that we're going to have and launching the poll, do you want to just touch upon that, and I'll go to my next question?
Okay, so we're going to launch a poll. If you all can just take a couple minutes and answer the questions. They're just very standard questions, so we can get to know you all a little bit more and touch base on your building type. So we just went ahead and launched. If you can answer quickly, that would be great. Thank you.
Wonderful. So is your association, condo, co-op, HOA, age of the building, under 20 years, 21 to 39, over 40? And how do you feel your association is prepared, positive or negative experience? So that would be great. Everybody that's on the webinar, if they could quickly fill that out, and we'll get back into the next question. And the next question I'm going to have as they're doing that is for you, Yvonne. We had talked a little bit briefly in our last sessions that we've had as it relates to egress and ingress, leaving and returning. And at Castle, we go through a variety of dry runs and rehearsals that was mentioned by Daniel, and we're sure that we're aware of testing items, lighting, signage, elevators, internal items related to the building and the community. But we also have the same exterior aspects, right? Which is, do you live in a gated community or not? When do the gates go up or not with certain hurricane speeds or not? Barrier island living, oceanfront, flood zones, bridge access points, and all of those aspects. And I know that there's probably some foundational advice that you give generally with regards to communicating what you can and can't do, but we also have to be cognizant of what are those local municipality orders specific to that area or that county. And really what my long answered question to you is what kind of light can you bring to us that is really for owners, vendors, and even our own site staff team with regards to there's a mandatory evacuation or not? And God forbid something happens, somebody stuck in an elevator that didn't heed the advice, or we felt and made a subjective view that what, this person's okay, they can stay, and then we're putting them in harm's way. So we obviously don't do that. But I think there's a lot of areas surrounding when you're told to leave, whether you can or whether you can't, and maybe some framework around that, Yvonne, is with regards to what you advise and some of the things we should be careful of.
Sure. Thank you. So mandatory evacuations are difficult to conceive and to affect and to get full compliance on. We have seen it over the course of the last several major storms that were threatening the area, that when mandatory evacuations come up, certain residents decide to stay in the building. Additionally, you have associations that for whatever reason feel it's necessary to have employees or personnel on the ground or in the building when they are in a mandatory evacuation area. It creates its own set of concerns and problems. We suggest to our associations that if you are in a mandatory evacuation area, communication needs to be sent out. They will be getting communication. Obviously, we know you go on, South Florida goes on 24-hour news coverage. You know what's going to be mandatory evacuated. You know when you need to get out. You know, those are things that are readily available to your community and to the public. But the association also needs to let owners know what is going to be happening within the building itself. And those are for those areas, you know, when you're talking about mandatory evacuations, you're really kind of looking at the coast and the condominiums or the communities that are on the coastline, not maybe so much your HOAs that are in your interior portions of South Florida. But when you're talking about that mandatory evacuation, you know, communicate to your residents that it is mandatory, they need to leave. The most important part is the services that are going to not be provided, meaning
Right.
your doors may possibly be open. We have no one here to secure your safety. If you try to take the elevator, you very well possibly may be stuck. You need to use only the stairs. You know, do not stay. We're not encouraging you to stay. You need to evacuate. And those that do decide to stay, making sure that management and the board both have the names and the phone numbers of those who've decided to take on that risk. We did have an issue after Irma where certain condominium associations in the Brickell area were being refused access back to the building. So there was at least some good compliance with regards to evacuation. Many residents stayed. The major calls that we received after the storm was that they had homeowners trying to return back to their community, and the community and local law enforcement wouldn't let them in. You know, that is something to be aware of, to make sure your residents know when you evacuate, you're evacuating for an unspecified amount of time. Just because you think the storm has passed does not necessarily mean that the area is ready to receive you back home. And so those are things that we want to communicate out to the residents. We suggest our associations make sure that they communicate and to really focus as the final kind of comment on who and what they intend, or who they intend to keep on property during the storm, and whether or not it is worth taking on that liability and risk to the association to have personnel or management present during that storm.
Okay. And Yvonne, you know, on that, you know, you've got mandatory evacuations, you've got the legal aspects of it, whether you can return or leave, et cetera. But I guess to your point, making sure that the association, the management firm and the board have a thorough plan discussed about what your rules and regs state, and then communicate to those homeowners that, by the way, if you decide to stay, these are the services that will no longer be in function or use or could be damaged. So it's just providing awareness, and it's up to the individual person to make that decision, right?
Absolutely. Yes, definitely so.
Okay. Okay. So it looks like we've got some poll questions and answers. Most of the associations here are condo. We've got one co-op, and then the rest HOA. And we've got a good mix of the age of the buildings, with regards to the majority of them are over 40 years. And so that's going to come into play with probably some of our Q&A at the end. I know that's an important topic with regards to new legislation with reserves and inspections and things of that nature. But for focuses of this webinar, I'm gonna ask this question to you, Jordan. And I know that insurance is not a fun topic these days. It's a difficult place to be in. I know it's not your fault. But you know, I think it's important because there is sometimes a lack of clarity with regards to what the options are. And I know we all know that premiums are escalating, going through the roof. Some are 20, some are 40, some are 240% increases. But we also have situations, right, where they're extreme, where now they're forced to do limited coverage or partial or no coverage. And maybe if we could spend a little time to give some clarity for the audience as to what's happening, why it's happening, and maybe what some of the optionality is moving forward.
Yeah, absolutely. So hopefully our participants in the audience didn't have too much of a heartache there when you said 20, 40, up to 240% increases. But unfortunately, that is the reality of the situation that some of our association partners are dealing with. And again, I mentioned at the outset, we manage about 750 to 800 associations in the Tri-County. So if you break that out, we're basically renewing insurance twice a day for a new association. So unfortunately, those numbers are fairly accurate. And I don't want to say that there's nothing that can be done, but there's a limited number of steps and items that can be done by boards and the property managers working in conjunction with their insurance agents. One of them is a little bit more of a rerun of what we talked about earlier, but right now information is king. So any sort of, it goes back again to for your property storm coverage, for any windstorm coverage. They're going to be concerned about the roof. They're going to be concerned about the windows. So do you have impact windows? How old is your roof? The threshold for how old a roof is deemed acceptable is changing carrier by carrier, almost month by month. Some of them say a roof life is good for 20 years. Some are saying 15, and some are just saying if it's more than 10, we're going to give you an unfavorable premium. That's the stance that's being taken. And unfortunately, we're building on every corner. So there's new buildings that have a roof that's less than a year old and that have brand new Hurricane Cat 5 impact windows. And those are obviously going to be the preferential buildings for the insurers to insure. Another thing you touched on is the capacity issues that we're dealing with. To not get too far in the weeds with insurance lingo, you have an insurance carrier on your policy and you might live in a $50 million building and they offer you $50 million of coverage. In reality, they're offering you $5 million of coverage and they're partnering with the reinsurance carrier, most of them international carriers, that are providing the excess layers to your policy. So if they're providing 5, their reinsurance partner is providing the next 45. Well, in the last probably 2 months, we've had the majority of the reinsurance carriers say, because of what's happened in the South Florida marketplace over the last 5 years, we can no longer offer reinsurance in that marketplace. The position that's putting our association partners in is one of two things: is some of them are seeing 100 to 200% increase, and some of them are being forced to buy what James had alluded to as what's called a loss limit, or maybe just drastically increasing your deductibles. A loss limit would be like saying, okay, your $50 million building, we're only going to insure the windstorm for 5. That's a scary proposition. And since we do have a lot of board members on the call here, I want to let you know what your assumption of risk is in that scenario. The condo statutes for the state of Florida state that you must buy adequate insurance for your building. The term adequate could be looked at as a little bit of a gray area. However, typically adequate is going to be deemed by the board, the property management company that's working there, as well as any lenders who are offering financing options into the building. So if you do decide to go this route of a loss limit, please understand that as board members, you are basically assuming the risk or the insurance for the remainder of the building that your property insurer is not covering. So that means if you have insurance for $5 million and you have 5 board members, you each are assuming $9 million per risk on that excess layer, because somebody has to cover that. Potential issues that you could run into while doing this, and this is why these items need to be discussed with your insurance agent and your attorney and your internal team. You may not have budgeting hard figures. You may not have an exact quote 120 days in advance, but this conversation needs to happen that far in advance for a couple different reasons. If we decide that, hey, we're gonna insure fully and we will take 100% increase if that's what comes our way, The quicker you are able to communicate that to your unit owners, and the quicker that you're able to build out a special assessment plan or find alternative financing, is going to make a world of difference. That is not a decision that you want to be making 5 days before you have to renew your insurance. Additionally, most banks will only accept up to a 5% hurricane deductible. So if you live in a co-op and nobody has any financing options, that doesn't matter. You can go to your insurance agent and say, hey, look, I know we have a 3% deductible. Show us a 5, show us a 7.5, show us a 10. Let's see if those options, maybe the increased deductibles, outweigh what the offset of premium we're going to look at. But again, if you're waiting up until the last second and you do have lenders in your building, you have absolutely no idea if they're going to accept the coverage. And let's say you move to a 10% deductible, and then some of the banks that are lending into your unit owners say, oh, you sent me this new certificate, that's not going to fly. I'm now going to force place coverage on your unit, Mr. Unit Owner. And now they're going to come back to the board of the property management company and say, why would you guys do this? Why wouldn't you check with the unit owners to see if this makes sense and is this a plausible option for us? So again, the overarching answer to your question, James, is keep as much documentation as readily available as you can. And when I say documentation, I mean inspection reports, I mean repair receipts, any sort of professional opinions you've received, whether it be engineering firms, whether it be from your attorney or your insurance agent. Make sure all of this information is compiled. Right now, the insurance carriers are asking for a lot more information than they ever have in the past, but they are always going to err on the side of covering their behinds. So if we don't have an answer for them, they're going to assume the worst. If we can't show them a receipt, they're going to assume it was never fixed. And that is only going to bring more heartache when you actually have to renew the policy.
Okay. Thank you, Jordan. And I think one of the other points to make here is, you bring up again the common theme and thread here is communication, right? So making sure that our property managers are reaching out to the insurance carrier to talk about the options, right? And then having that meeting with the board to say, okay, guys, it's bad news, but it is what it is. But these are the options, and these are maybe some creative ways to look at, bridging or gapping some of these issues for the short or long term. So we just have to have those conversations, right?
Exactly. And typically, look, as is probably a common theme with all of our businesses on here, bad news sucks when you have to deliver it. But if you deliver it in a timely manner where we can make adjustments and we can adapt to it, it's acceptable. When you drop that bad news on somebody 5 or 7 days before they need to renew an insurance policy and they feel like they're stuck in a corner with no options, that's when things get really ugly.
Okay. All right, great. So Daniel, it looks like you're getting lonely over there. So I'm gonna switch and pick on you, but it's probably a good segue because I myself am not the most versed on a public adjuster, right? And I think that there's a large audience of people that maybe don't understand the use and the role and the when and when not of a public adjuster, but also with Global Pro, how you work in that space and provide, value for management firms, associations, board members. Can you, whether it's public adjuster or not, but in that kind of envelope, can you just talk a little bit about where you've been working in these spaces and why it's important for them to know what you're doing and why you're doing it?
Yeah, so the public adjusting industry has two black eyes right now, I would say, as well as the plaintiff trial bar. Certainly because of the last few legislative sessions, when it came to insurance, it was the public adjusters and the plaintiff trial bar that were getting that received the haymakers and were painted as the cause of this allegedly bad insurance market that we're in. And I say allegedly because while it is bad for the consumer, the policyholder, it's been very good to the insurers who sell insurance to community associations. And I can say that factually because if you actually go look at the commercial insurers, most of them are surplus lines insurers that are not in the state of Florida. They've all reported billions collectively, if not trillions of dollars in profits during a time in which they allege that the market has been so bad to them in South Florida that they can't make money, they're leaving. Now, one of the confusing parts of that message is that a lot of the issues that the legislator are trying to address are specific to homeowners and have almost nothing to do with commercial lines insurance that is sold to community associations. It's a convoluted message. In fact, if you go look at the recent governor's order and you read it, you'll see in there that it mentions nothing about commercial lines insurance. It only says homeowners insurance. However, the legislation proposed by an insurance agent who is in the legislature that has one of the largest funded campaigns by insurance companies, lobbyists. Okay, if you go look at these details, addresses not just homeowners market, but the insurance market as a whole. And the question is that why, if most of us are actually buying insurance in a surplus lines market and not here locally, why is this an issue? Why are all these issues being painted as if it's plaguing the insurance market as a whole in South Florida? And not to get into a very technical conversation, but it comes down to capacity and it comes down to reinsurance that is sold to the insurers for the placement insurance here. And then they're the ones complaining of it, but they own the managing agent, the companies that actually set the price on these things, which the profits from that is unreported. So in effect, there's a bit of a high to the ball, so much so that the reporting requirements in Senate Bill 76 as of last year were not complied with, arguably, this year in anticipation of additional legislation that was going to get passed to curb and help the issues that are plaguing these insurance companies here, which was largely sold as fraud and legal fees. One of the things that was supposed to be reported in Senate Bill 76 was the cost of the litigation, the claims you paid. It was not reported on. In fact, the person that drafted the bill and then came out and said, well, we're not sure we read it that way, we think it's next year, but ran on a campaign this year to pass more legislation on allegedly the cost driver for insurance being the cost of the litigation, even though it was not even reported on, right? So very confusing, right? Secondly, there's conflicting language in the actual statutes. And when asked about that conflicting language between Senate Bill 4D and the Senate Bill 2D, the response was, well, we'll have to figure that out. So all this legislation changes that you've seen to date, as the actual trial bar will tell you, is only going to result in even more litigation. It already has actually led to the state of Florida itself getting sued and various other people getting sued based on it because these laws went into place the moment the bill was signed by the governor. So there's actually more litigation now because of the legislation they passed that's allegedly was supposed to curb it, because the legislature did such a terrible job at trying to curb the issues that they believe is causing this dysfunction in the insurance market. One of the biggest things about the fraud, and I want to get to the public adjusting and answer your question directly about fraud, is that if you actually look at the Department of Financial Services website, those that are committing the fraud, and this is not, and I'm gonna qualify the statement, George, so don't jump at it, are actually insurance brokers, not selling property insurance. If you actually look at the fraud that's being committed in the state of Florida right now, which allegedly is leading to the issues in our property insurance market, are not policyholders largely, are not, almost entirely has nothing to do with property insurance. Yet that has been used as a basis as to why we're having this complicated conversation about the issues plaguing insurance and seeing these massive rate increases, that these surplus lines insurers who don't even have, some of them, I've actually done the research, don't even have real estate holdings or investments in business or anything to do with the actual United States. They have actually no money in the United States and are complaining about the issues going on in the United States as the basis as to why they need to raise the rates. So you need to start questioning these things. That's why I want this little conversation. And also to demonstrate that as an insurance expert, as I will hold myself out to be, because I have testified in court in both federal, state as an expert in coverage and bad faith and et cetera, I can tell you that you need to start looking a lot more closely at the policies being sold to you. Consider these things. And as a licensed public adjuster, which I am, and several others are on my staff, we're 16 employees, but I will actually say that the minority of us are actually public adjusters, because to adjust the claim today with the policies we have and the laws that we have throughout the country, which I operate in many states throughout the US, it's become so increasingly difficult to determine where coverage is that I believe, and I have proven that it takes more than just the knowledge of how to adjust a claim. Now, the role of a public adjuster is to represent the interest of a policyholder. And if I look at the bylaws of most community associations, if you were to engage in a bid process or to actually do a construction project, you would actually hire an engineer or an architect or an owner's rep to help guide you through the process. You have an obligation to do that. Why? Because you're protecting the fiduciary interests of your unit owners. However, when dealing with hundreds, if not millions of dollars worth of damages to your building, associations don't feel the obligation or necessary need to actually hire someone to represent their interests. However, when you have a claim or a loss, you have no one actually legally representing you in the adjustment of a claim if you do not have a public adjuster or a duly licensed attorney who is acting as your adjuster representing your interest. Again, most bylaws require even a small construction project needs to go before committee, even requires an owner's rep, everything else when you're going to spend money. But when you're talking about loss and damage, for whatever reason, associations don't think they need to be represented because they have a broker. Well, a broker's job is to sell a product. It's not to adjust the claim. Now, they do have people on staff that understand claims. Most of them used to work for insurance companies. They have no experience in representing a policyholder. So you can understand where they've been drinking their Kool-Aid and aren't going to understand, quite frankly, what you need or what your obligations truly are as a policyholder, which is very different than the perspective of someone who's worked for insurance companies. We don't work for insurance companies. So, and once you've done mitigating your damages, which is your only obligation under an insurance policy immediately following a loss, to rebuild is a construction project. And when you're spending hundreds, if not millions of dollars to rebuild your property, why are we skipping the step of having proper representation, determining what our budget really is to rebuild? Because that's what the claim is, right? That's your budget. The money you're going to get paid at is the amount of money you're going to spend to rebuild. If not, then deductibles, issues like that, the depreciation you're going to recover that money through an assessment or a credit line or a loan. But you're further going to indebt your unit owners and your association by making those financial decisions, even though you haven't had proper representation to actually ascertain, to determine the true amount of damages owed to you. And we've had claims that where an insurance company came out, didn't deny a loss, didn't provide coverage, just delayed the process by 4 months and resulted in over a $70 million recovery. We've represented an association in something that significant. Single largest claim this insurance company ever paid out in the United States, right? We represent claims all the time. They're hundreds of thousands of dollars, if not millions of dollars all the time. And I can tell you, most of those claims that come through our doors was improperly noticed. Usually there was a phone call or an email to a broker and still improperly noticed, right? And went from denial to payment. And so I think what I'm trying to demonstrate here is that you don't know what you don't know. And don't be an expert. And if you're obligated to hire an architect, an engineer, or set up committees to do these things for small construction projects to decide on the type of carpet and paint you're going to put in your building, then why do you think, as a community association manager or a board, that you don't need a licensed public adjuster, duly licensed attorney representing your interest in making tens, if not hundreds, if not millions of dollars of decisions, financial decisions for you and assisting you through that process is baffling. And that is the role of the public adjuster. Ascertain your damages, advise you through the process, represent your interest in dealing with the insurance company. These policies are complicated. I have attorneys on staff that actually all they do is review policies. They go and review the case law. They review the legislation. They are providing interpretations of these policies to assist us in figuring out what you're owed. You as a board do not have access to those types of resources. And the best part, and I'll leave it at this, is we work on a contingency fee basis. So there's no money up front out of pocket. It's based on performance. So whatever you get a recovery, you get paid back. That's how it works. I would say on average, the market is anywhere between as much as 20% to 10%, depending on the complexity of the claim or the type of loss that you're handling. And I would encourage you, ask for references if you're going to hire a public adjuster. Make sure that they're actually qualified to do the work. Just like if you're going to Yvonne's firm, you're not going to just go over to a firm that does construction law that wants to act as if they do community association work suddenly. There's a lot of people out there right now trying to work from home, keep their firm small, whatever else, try to be a lot of things that they're not, because they went on their own during the pandemic, right? So be careful. Make sure you ask for qualified references. The last bit of this, and I'll pass it back to James, is the question was when not to hire a public adjuster. I don't know. I'm of the opinion that there's never a bad time to at least inquire as to how an adjuster may be able to assist you through the claims process. There's times we get phone calls, we look at the claims and we look at them and say, look, there's no coverage here. Or look, the claim is $25,000, 30 grand. It's a pretty straightforward. Here's the highlighted section. Here's some forms you need to fill out. Go ahead and do it. Like let's keep a relationship, keep a conversation going. We'll help you through the process. And by the way, for public adjusters can assist you with both first party and third party insurance claims. Meaning, if a unit owner was negligent and caused damage to your association's property, we can't adjust that claim. We're not going to litigate and sue the other unit or the contractor responsible for it, but we can adjust the claim if there's an insurance policy in place. And a lot of times your managers, I know Castle has an incredible process for collecting those certificates of insurance. We can actually initiate that claim and go and pursue those loss and recoveries. Another benefit of a public adjuster, because again, we're not looking for hourly fees. We're not looking for large retainers. Again, it's simply based on performance. And free evaluations, right? We go out to the property, we work with you, make sure you understand what's going on. So I think I fully answered your question there, James. I had to get something off my chest about the insurance market and the mess, the garbage dump of information. And I call garbage is the big one. Garbage in, garbage out. That's all we got this legislation session on insurance. It was total garbage. It's not going to, in fact, I'm sorry, I keep talking here, but the last bit I will say is that even the guy that wrote or was responsible for promoting the bill said he does not actually think the legislation that was supposedly passed to help with the insurance market in Florida does not expect to see any sort of impact in the first 18 months, if ever.
Wow. Well, you touched upon a lot of points, which is good because it shows that we have to be very thorough in our curiosity and asking questions, whether you're a vendor, board, association, management firm, et cetera, to really have a thorough understanding of what the optionality is and when not to use certain types of functions and vendors. So thank you for that, because I think our next webinar can have a whole topic just on that in itself, right? But that was very, very well done. Guys, I think for the sake of time, it's 11:50. If we can, Lindsay, Jerry, I'm not sure how many questions have come in. I don't have anything to look at, but do we want to do a little Q&A to just finish it off here?
Yeah, if anybody has any questions specifically, I didn't see anything come in, but feel free to ask any specific questions you've had on your mind during this discussion, and we will feed them to our panelists so they can answer you before we get off here.
Okay. So while hopefully we're getting some questions, or maybe not because we're just that thorough and good in our responses, I'll probably just touch upon a few things. There's hundreds of things that management firms go through in terms of kind of the best practices and preparedness. And I'm just going to list a few things briefly because as property management and in property management, there's a lot of areas that sometimes fall through the cracks. And that's why, again, I speak to, we're so focused on a methodology, a best practice so that we mitigate issues from reoccurring. But, I'm going to throw out a bunch of things that you can note down to just make sure you ask the question or at least think through. Shutters. Do you have shutters at the clubhouse or personal residences? Condominiums, do you have them or not? When do they go up? When do they come down? How do you communicate that? Are there legalities around that? Do you have even vendors to do the work? Can it be your on-site team or not? So, review your docs, your rules and regs, get with your association attorney, of course, but things like that sometimes fall by the wayside. And if you don't have a control plan, if you don't have effective communications and do some of those dry runs, they will get lost. So make sure that you reach out to your vendors. Landscaping vendors is more probably applicable and larger in terms of the HOA, but here again, are you on their list, right? Do you have set pricing or not? And as Daniel alluded earlier, they can only handle so much. So you really have to vet the proximity of where they're staged and where their fleet is to help remove debris. and help get that removal. So you do have access points that you can get in and out. Is it in your budget? Do you have contingency for those types of things? I'm just thinking out loud. Generators, equipment list, right? Do you have a go-to person in case there's something that fails or falls down or is a backup? And then, photography, that's big for insurance and for Global Pro and for attorneys, right? Like, make sure that you're going through and documenting and taking photography of everything you have in your common area in your community before and then after. And then after is that really assessment to say, what kind of remediation or repairs do we need to do that we can do ourselves on site so that it doesn't increase? And then what things are going to have to go to the insurance that are major, if that's the case. So, I think all that there's hundreds of things that will drive out of going through your own internal communications plan, hurricane preparedness plan. At Castle Group, we call them 100%ers. Every property must have a hurricane binder, and that binder is that hurricane Bible, right, if you will, that really goes through everything we just discussed on this webinar, so that you have a very clear and concise checklist to mitigate risk and to know where you go and what you do and how you do it, and who's the person and resource for that. So those are just some things that I would make sure that as board members, as property managers, as associations, whether you're professionally managed or not, to make sure that you think through and obviously do them in advance, not now, but if you haven't done them, do them now for sure. Any questions that have come in, Lindsay, since then?
Yes, we have one for Dan.
So their question is, what's your opinion of disaster recovery companies? I think they fall into two different silos, if you will. You have national companies that do a lot of community association type work, and then you have franchise companies. In my personal experience, the franchise companies, and I'll stay away from naming names. But if you're dealing with franchise companies, there's only a few franchise companies, and I think it's two that come to mind. Two of the franchise within these franchises throughout the country, let me say it that way, that I think in the South Florida market have the capacity to be able to manage maybe a few buildings after a major hurricane event. And because of that, franchised companies are, to me, not your best solution and go-to when it comes to recovering from loss and damage. Why? Is because these franchises, the operators come into the market and will literally compete, even though their documents, as I've been told, do not allow, or in one instance, they're actually required to allow them to compete because of a resource issue. But the issue becomes have their billing practices. And when you have an issue of billing practice, as Jordan will tell you, and actually one client in common of ours after Hurricane Irma comes to mind, where they did hire one of these franchisees, and they started billing them for all kinds of things, hotels and beverages and food service and all these other things that you're not going to see from one of your locally bigger companies or national firms that actually own and operate all of their entities and companies. Okay, it's a totally different feeling and look, and I believe me, their access to resources is much more adequate and fluid and better. And so just be concerned about those billing practices. And as it relates to this, Jordan made an incredible point about documentation. And when he's talking about documentation, I know what he's talking about is not only placing the insurance today, but once you've recovered from that loss and damage, collecting that documentation, as he mentioned, about making the repairs, making sure that you have correct documentation as to what was actually done. And some of these companies, smaller businesses, for disaster recovery businesses, don't have adequate access to technology, which you do need today, technology, in order to comply with the requirements in the policy. The policies are very specific about the itemization of your damages that you're claiming. And it's not only today, it's tomorrow, and how important that is for Jordan and his team and what they do when you need to actually place insurance next, and making sure that if you tore something out, that it was rebuilt and that you have coinciding documents that are back and forth. And I would say for Yvonne, I know, and I've again worked extensively with Siegfried Rivera on vendor agreements, the review process. I know we're all in a rush, but like for the life of me, I beg of you, take your time. If you're dealing with a new vendor, just because the tennis courts aren't open the day after a hurricane, or because John on the penthouse level, who's got all the money in the world, and can hire as many people as he wants, take your time. And don't work at their speed, work at yours. Take heed from your own cadence and work with your experts, the Jordans of the world and the Yvonnes, and make sure that those documents get reviewed before you shove it off to the association. Yvonne, I throwing it to you real quick. I actually had an association ask me about getting a power of attorney recently, to be able to execute a work authorization with a mitigation contractor. And I thought it was very interesting. And I guess for James at Castle, being as big of a company with the amount of resources you have, I mean, what are your thoughts on it? I was like, wow, I've actually, in over 10 years of doing this, I've never actually had someone ask me about it. Their question was about the fact that people are remote now. And so it'd be so easy for them to go remote, and they're on site. Do I sign the work authorization or do I not? And the board wants to give it to me. Do I expose myself to any legal, and what is, Yvonne, I guess, what are your thoughts on that? And James, like, does Castle, is that as a business practice of Castle?
So we have, luckily, with regards to the state of Florida, the protection of the Emergency Powers Act for boards. So as soon as a state of emergency is declared for the region, the associations have the ability to tap into resources with regards to emergency powers and the statutes. We've used them at length over the course of the last couple of years with regards to COVID, because we were within a state of emergency within the state and federally. And so those provisions within the Florida statutes do allow associations to execute on contracts without certain board meetings, without going to have to do the formalities of approving it with a board. So there is really no need for a power of attorney. Having somebody ask you for a power of attorney is a little suspect in my review. It always causes an issue. And Dan, to your point, I just received crazy and a contract from an association where the association was essentially reserving the generator, but not on an exclusive basis, on an maybe we'll have it for you basis. So they are paying every month for the remainder of this hurricane season through the end of December for the purposes of using a generator with no guarantee that when they need the generator will be available to them. So there's a lot of these little kind of, I'm not going to call it a scam, but yeah. I mean, maybe that's what it is, but there's a lot of these contracts that are coming around and to your point, that are being thrown underneath associations and saying, here, we're going to offer you this service. Now's the time to be aware that these types of companies come out of the woodworks to kind of try and make the best deals possible for themselves, not necessarily for your association.
Yeah, I think the word I was thinking was suspect, right, Yvonne? So
here you go.
Yeah, it's but all good points. So guys, it is 12:01. I just wanted to just briefly say, you obviously see on the screen here, for those that are participating, here are our name, our contacts, and please, we encourage you to take any of these emails down and reach out to us at any time for any questions. We would love to continue discussions with you on an individual, group basis, however we can provide value. I want to thank Lindsay and Jerry for being the facilitator, orchestrator behind the scenes, helping us run to point. And really, I really want to thank Yvonne and Siegfried Rivera and Jordan with Brown & Brown and Daniel with Global Pro. You guys are the best of the best in the industry. We're very lucky to work with you at our associations. And this was fun, and let's do it again. So until then, thank you everybody for participating.
Thank you very much.
Thanks, everybody.
Thanks, guys.
It was a pleasure.
Awesome.
Thank you, everybody. Take care.
Bye-bye.